Welcome back, distinguished delegation, colleagues, observers. We have very little time left now, so I'm going to give the floor immediately to the delegation to give such responses as it's able to give at this stage, and then there'll be the wrap-up first from the distinguished head of the delegation and then from myself. So with that, I hand the floor to the delegation. Ambassador Arya Sinha, you have the floor.
Mr. Chairman, we have to stop at 1, you said, is it?
I'm afraid.
All right. Thank you, Mr. Chairman and members of the committee. What I'm going to do is to try to get those who have some of the issues which have not been touched on attended to first, and in that in sometimes very specific queries. So first of all, let me ask the Secretary for the Special Board on Reconciliation to clarify, because there was a question about the LLRC and the National Plan of Action, and I would like him to clarify how those numbers of recommendations have been worked in. Mr. Diwarat.
Thank you, Ambassador. Mr. Chairman and the distinguished members of the committee, with regard to the question number 13 and the statement made by the distinguished member of this commission, Mr. Shani, that the government of Sri Lanka has been selective in implementing only some of the recommendations of the Lessons Learned and Reconciliation Committee, I wish to state that the Chapter 9 of the LLRC report, titled Summary of the Principal Observation and Recommendations, contains 285 paragraphs, which is the sum total of observations and recommendations. Several of such recommendations are widely similar, have common objectives and outcomes, and are repetitive. The government has identified 144 as recommendations with the approval of the Cabinet of Ministers, which have been clustered in the LLRC National Plan of Action under 5 themes. These themes are: number 1 is international humanitarian law issues. 7 recommendations are pertaining to that. Number 2 is human rights. 54 recommendations goes on that. Number 3, land return and resettlement. 24 recommendations in respect of that theme. Then restitution and compensatory relief. There are 9 recommendations on that. And number 5, reconciliation. Large number on that, 50 recommendations. These recommendations have been comprehensively incorporated into the LLRC National Plan of Action and are now under implementation. Further, all agencies assigned with the implementation of the National Plan of Action are instructed to consider the recommendations in the entirety and implement them in the spirit in which they had been made in the LLRC report. However, originally defined time frame could be amended if it becomes necessary for further extension. Of the 144 recommendations contained in the report, 46 have realized their objectives, and 88 recommendations which have long-term implementation timeframes are well underway. I trust this response clarifies the issues raised by Mr. Shani. Thank you, Chairman.
Thank you, Mr. Diwarat. And as I mentioned earlier, he is the Secretary to the newly appointed Special Board on Reconciliation. And previously, from the time the conflict was coming to a close, Mr. Diwarat was the Secretary of the Presidential Task Force, which brought to safety the 300,000 people, looked after them in the camps, and resettled them, sent them back to their homes. Now let me turn to the Secretary to the Ministry of Resettlement, Mr. Janaka Sukatadasa, and Mr. Sukatadasa would be addressing the question 22 in essence, and also any other matters which arose in the discussion relating to the IDP issue as present.
Thank you, Ambassador. Distinguished Chairman and members of the committee, I would like to respond to the questions specifically referred to by the member, Mr. Filterman, relating to IDP question in Sri Lanka, including the return of their land and property. Mr. Chairman, as of 31st August 2014, GOSL has successfully resettled 228,298 families, consisting of 774,447 members in the former conflict zones in the northern and eastern provinces of Sri Lanka. At present, only a total of about 7,840 families, consisting of 26,056 members, remain to be resettled. Accordingly, the percentage of those IDPs remain to be resettled is just 3.3% when compared with the total number of resettled and already resettled. As regards to the IDPs to be resettled number raised by Mr. Filterman at 90,000, I am glad to report that the government of Sri Lanka has conducted a joint study with the United Nations High Commissioner for Refugees in Colombo to identify the exact number of IDP families in protracted displacement. And the numbers I quote, that the 7,840 families consisting of 26,056 members is the outcome of this study. In any case, we will be publishing a joint report with the United Nations High Commissioner for Refugees in Sri Lanka once this matter is finalized. As a matter of policy, GOSL is committed to make available durable solution to all the internally displaced and resettled families, and the framework within which it intends to do so is clearly spelled out in the government's overall policy. Mr. Chairman, with regard to the provision of durable housing and shelter solution to resettled families, I am glad to note that 65,747 new houses have been constructed as at 31st August 2014, and 9,246 partly damaged houses have been renovated with the facilitation of government and other donor agencies. At present, construction of 23,713 houses is in progress. Further commitments have been made to construct 9,367 new houses and renovate 2,820 partly damaged houses. A significant portion of these houses are being built on owner-driven basis. Mr. Chairman, on the question of return of land and property of those displaced, over the last 4.5 years, Sri Lankan security forces have progressively released land held by them to facilitate resettlement. In fact, the total private land held by the security forces in the northern province of Sri Lanka has now reduced to 7,382 acres from around 25,627 acres in 2009. Among those displaced and already resettled, only about 637 families could not be resettled in their places of origin and had to be relocated in close proximity to their original habitat for the reason of their land being required for various public purposes. Mr. Chairman, Government of Sri Lanka maintains 32 welfare centers in the northern province for the benefit of 1,184 internally displaced families who are in protracted displacement. However, 790 such families do not own land in their places of origin and in any case are landless. However, there remain 4,815 displaced families in the Jaffna district living with host families. Their land totaling to 7,382 acres are earmarked for acquisition for public purposes. The legal owners of such land will be paid compensation once the acquisition proceedings are completed. However, legal action filed in courts against proposed acquisition is pending for determination. Mr. Chairman, with regard to the resettlement policy in general and the gender equality in particular raised, by the honorable member concerned, I would like to point out that the gender equality is very well recognized in the draft resettlement policy. All IDP families disregarding their gender would be recognized and accepted in equal measure in the provision of assistance and other entitlement. Mr. Chairman, further, under the same resettlement policy, both men and women have equal rights to obtain necessary documents and have the right to have such documentation issued in their own names. Mr. Chairman, I trust that the above clarifies the issues raised by the distinguished member of the committee. Thank you.
Thank you very much, Mr. Sugurdasa. Let me now move on to Secretary Women's Affairs and Child Protection Care and Women's Affairs, Mr. Eric Iliaparachi, who will respond to issues raised in questions 18, 19 and 20.
Thank you, Ambassador. Distinguished members of the committee, yesterday and today also there were queries regarding the discriminatory provisions in the the personal laws such as Canadian law and the Jaffna law. I wish to state that in the Supreme Court judgment on the application of the ICCPR, which was elaborated in the answer to the question number 1, the court noted that the Article 27 of the Covenant makes a special reservation that in the states in which ethnic, religious or linguistic minorities exist, persons belong to such minorities shall not be denied the right in community with other members of their group to enjoy their own culture, to profess and practice their own religion or to use their own language. In the court's view, it could be contended that the provisions of Article 16(1) of the Constitution that only provides for the continuance in force of already operative law could be considered to be inconsistent with the Covenant only on the ground that there are certain aspects of personal law which may discriminate women. The matter of personal law is one of great sensitivity. The Covenant should not be considered as an instrument which warrants the amendment of such personal laws. If at all there should be any amendment, such request should emerge from the particular sector governed by the particular personal law. Also, the government is now in the process of amending provisions in the 3rd schedule of the Land Development Ordinance, and a bill in this regard is in its draft stage to bring it accordance with the provisions of the Matrimonial Rights and Inheritance Ordinance. And there was also a concern regarding the female ex-combatants with reference to the comments made in the question 3 by the Human Rights Committee on Female Ex-Combatant facing a high risk of rape and violence. The government wishes to state that this allegation is without basis. If indeed specific information has been made available to the committee which has led to this assertion, we would urge the distinguished committee to share such information, enabling the government to investigate and respond. It must be reiterated that Sri Lanka has a well-established zero-tolerance policy on sexual, gender-based violence against women and continues to take stringent action against the reported case. And there was also a concern in the morning on the status of the Women Charter adopted by the Cabinet in 1990. Let me say that it is not only in force; it is the primary document which shows the activities to be taken by the government and especially the Ministry of Child Development and Women's Affairs, and there is a separate committee separate institution, that is National Committee on Women, is mandated to implement the provisions in the Women's Charter. In fact, this institution has been strengthened. A new office space has been provided for them, and also the new committee and a new chairperson has been appointed recently, and also a complaint desk within the headquarters of the ministry itself. A complaint desk and a help desk has been established, which is being managed by the National Committee on Women. So this shows that this National Committee on Women and the Women's Charter is very important, and government has given priority for that. In fact, in this year, additional 700 rupees was allocated to improve the matters in regard to women, and a considerable portion of this budget allocation will be set aside for the National Committee on Women and the implementation of the Women's Charter. Thank you.
Thank you very much. Response 21 and 23, please.
Thank you, Mr. Ambassador. Mr. Chairman and members of the committee, I wish to thank Ms. Zebedfer for recognizing that the State Party has taken considerable action under the issues that were highlighted under question 21. May I just reiterate the government position that the Ministry of Justice has indeed established an anti-trafficking task force to combat trafficking in persons, especially of women and children. The task force comprises representatives from important government organizations as well as international non-governmental organizations. And they meet under the chairmanship of the Secretary, the Ministry of Justice. The task force, if I may elaborate, meets once a month and has developed a national action plan of action, as well as standard operating procedures, which are to be laid before the Cabinet of Ministers very soon. May I also state that the victims are assisted and protected and are given the normal rights and remedies. The task force is seeking to combat trafficking of victims to other countries as well as locally. May I also bring to the attention of the committee that a shelter has been established for trafficking under the aegis of the Ministry of Child Development and Women's Affairs and is now fully operational. If there is any further information, we will endeavor to provide it in writing. Moving on to the issues expressed in question 23, may I state that the government of Sri Lanka rejects the assertion that there is a continued trend of attacks on freedom of expression, peaceful assembly and association, particularly against human rights defenders, journalists and families of victims. We maintain that there are unresolved cases of violence against media personnel, but that there is no restriction placed on what may be reported by the press. We wish to state that the law of evidence plays the most crucial role and that due process is required for prosecution, and there is a necessity to have adequate evidence in order to file cases in court. May we also state that in recent years there has been a spread of social media networks and online news outlets has contributed to the diversity and the increasing speed of the propagation of information throughout the country and overseas. May I invite the committee to take note that the wide spectrum of views on display in Sri Lanka is amply demonstrated by its print and electronic media, much of which, I note to the committee, is fiercely critical of the government. If one were to log on to the internet and read the e-news or the newspapers, one will take note of the fact that there is quite a lot of criticism of the government. It should also be noted that during the period of the present government, no press censorship has been imposed. Further, the law relating to criminal defamation has been repealed by Parliament, and these steps, it would be hoped, would be noted with the positive attention that the media does operate in a framework where the law permits free expression of views. Sri Lanka remains committed to taking steps necessary to ensure the safety of media personnel and institutions. Although no specific laws have been formulated with regard to media personnel or institutions, any person who seeks to vindicate their rights has the right to file applications of fundamental rights in the Supreme Court or a writ application in the Court of Appeal, or in the alternative, to make a complaint before the Human Rights Commission, either on their own behalf or on behalf of the public interest. So I think I wish to draw that to the attention of the committee, that the legal process for any person who is aggrieved by any action they perceive is prohibitive of their expression can always complain to court. And the courts have indeed, as alerted to previously, entertained fundamental rights applications, not only on the behalf of persons who actually file them, but also in the public interest. The full gamut of constitutional guarantees, including effective remedies, is available to individuals and groups and media personnel in this regard. The government is also pursuing investigations into current cases of alleged attacks on media personnel and institutions, and as I mentioned before, there has to be sufficient evidence in order to institute court cases, and this is a fact that is largely to be noted in common law jurisdictions. The government has also initiated action to prepare legislation in regard to the witness and victims protection, which was again mentioned to the committee previously, and one hopes that when the bill becomes law, that too will help any person who wishes to make complaints with regard to if they are of the opinion that there is a infringement of their right to expression. Details of such proposed legislation, as I already said, have been made to this committee, and I hope that those concerns that were expressed by Ms. Zibert have been adequately dealt with by my response. Thank you, Mr. Chairman, Mr. Ambassador.
May I now invite Deputy Solicitor General Naren Pulle to address the issues raised in under 14, 15 and 17, please.
Thank you, Mr. Ambassador, Chairman and members of the committee. I would propose to deal with the questions referred to under issues number 14, 15 and 17, and with specific focus on some of the questions raised by Mr. Newman as well as the other members of the committee in the context of these three questions. Let me commence my answer with reference to question number 14, and in the context of the Convention Against Torture. Let me at the outset bring it to the notice of the committee that the government follows a zero tolerance policy on torture. I wish to emphasize on that because that is a principle that is followed within all organs of government, and that zero tolerance policy is reflected if one were to take note of the fact that even the establishment's code which governs the activities of public officers, when the Attorney General is called upon, there are certain fundamental rights cases that are filed in the context of torture alleged under Article 11, and at the outset the Attorney General, it's a policy decision that Attorney General will not take up the defense of a personnel who's officer who's been where allegation of Article 11 has taken place, and there is a specific stipulation in the establishment's code in that context. So the zero tolerance policy of torture is manifest both as a matter of policy in the establishment's code and the Attorney General in taking up defenses of officers where allegations of torture have been made. So I wish to emphasize on that at the outset, and also note in the context of some of the questions that were raised in this regard, that the government is of the opinion that the definition of torture in its domestic law covers all elements contained in Article 1 of the Convention against Torture, other cruel, inhuman, or degrading treatment or punishment. Now, although the word suffering is not specifically mentioned in the definition of torture in Act number 22 of 1994, the government is of the view that the word severe pain, I quote, severe pain, whether physical or mental, invariably encompasses suffering, both in its physical and mental form. Now, having said that, Sri Lanka is of the view that this definition is consistent with the definition of torture contained in the Convention. Now, it has to be noted that purely mental torture also included within the definition is also included within that definition, so that the threat of torture may itself amount to psychological torture. Further, the government notes, I think that is a matter which needs to be taken cognizance of, that Professor Manfred Nowak, former special rapporteur on torture, in his report of February 2008, observed that the definition in Article 12 is in conformity with the definition of Article 1 of the Convention. However, it does not expressly include suffering. This is a clear indication that despite the lack of the term suffering in the Convention Against Torture Act number 22 of 1994, the CAT Act is consistent with the definition of the Convention. Now, according to the Torture Act, torture is defined under Article 12, which in principle corresponds with Article 1 of the Convention, as an act which causes severe pain, physical or mental. Slow. Very well. Okay. Having taken note of the fact that there is an explanation that we have already provided, I would not, having regard to the time constraints, proceed further on that aspect. But I would reiterate the contents that we have already made in that context and request that the committee takes note of those matters. Now, with regard to issue number 15, I would also bring it to the notice of the committee that the draft bill to amend the Code of Criminal Procedure Act number 15 of 1979 was sent for the Attorney General's observations, and the observations have been sent to the Ministry of Justice. Now, this amendment proposes to enhance protection of an arrested person, as well as make provision that could be required to provide for the proposed amendments to the Human Rights Commission Act. Now, these observations have been made, and it must be noted that as per the existing law and practice, whenever an arrested person is in need of medical attention, it is the duty of the police to provide him such assistance prior to being brought before a judicial officer. Now, there was a question also raised in the context of the Witness and Victim Protection Bill. I might bring to the notice of the committee that that bill was placed on the order paper of Parliament. In terms of our constitutional procedures, there is provision for a person to challenge any bill that is placed on the order paper of Parliament within a week, and that this matter has been challenged before the Supreme Court, and the Supreme Court's determination would be sent to the Parliament, and pursuant to the receipt of that determination, Parliament would deliberate, having taken cognizance of the Supreme Court's views on the constitutionality or on any other matters that may be noted in its opinion. So this is the current status of that particular aspect. Now, there was the question posed. I'm mindful of the time constraints, Mr. Chairman. and members of the committee. So I will be very brief, but I would like to at the outset make a note of the fact that there were references made in the context of question number 17 to the impeachment proceedings, as well as aspects covering the independence of the judiciary. I might say at the outset that the administration of justice, inclusive of the independence of the judiciary, is constitutionally enjoined, and any infringement of these entrenched rights is vested with sanctions. Judges hold office during good behavior, and proven misbehavior or incapacity triggers constitutionally entrenched disciplinary proceedings. Now, I would say that any procedure adopted in this regard has, with regard to the matters raised in the form of questions, has been in accordance with the Constitution of Sri Lanka, and such action is in compliance with the constitutional provisions. Now, there were several references made to the particular judgments. I am somewhat, I wish to note that whether the committee had been appraised of all the judgments delivered in this particular matter, because there are 3 judgments of 5 judges of the Supreme Court that dealt with this issue. One dealing with a special leave application preferred by the Attorney General with regard to the decision taken by the Court of Appeal. Now, that judgment very comprehensively addresses the constitutional aspects as well as the legality of the proceedings. I beg to differ with the observation to say that there was no question about that it was dismissed purely on a jurisdictional matter, because I would emphasize the fact that what the judgment in this particular case, which I would make available, SC's appeal number 67 of 2013, dealt with, while dealing with the constitutionality of the process, the court in fact observed that the Court of Appeal did not possess the jurisdiction to make the orders that it made. So I think the jurisdictional aspect of it was dealt with in that context. But the Supreme Court, in its determination, with clarity and with reference to several judgments from other jurisdictions, I must say that this was a very, the judgment itself deals with the established practice and the procedures that had prevailed in Sri Lanka for over 30 years. This was not an ad hoc procedure brought into place. This procedure had been in operation for almost 30 years. At the time, I would say it was brought in terms of the standing orders and the Constitution. Standing Order 78A, and read in conjunction with Article 107 of the Constitution. The provisions are very elaborately set out, and a clear interpretation is provided. In this context, I must bring to the notice of the committee as well that the sole and exclusive jurisdiction of interpreting the Constitution is vested in the Supreme Court in terms of Article 125 of our Constitution. Now, that jurisdiction had been invoked had been applied by the Supreme Court, and a very clear analysis of the provisions were made, and the court made a pronouncement based on those on an analysis of those constitutional provisions. There were arguments for several days on this matter, and all parties were given opportunity of making their submissions. A comprehensive hearing was given to all parties, and it was in pursuant to that process that the Supreme Court came to this conclusion, and 5 judges of the Supreme Court have made this pronouncement in this application 67 of 2013. And I must also bring it to the notice of the committee that apart from this judgment, there is also a judgment of the Supreme Court dealt with in applications, in 4 fundamental rights applications. So I'm not aware whether the committee has been appraised of all those matters, but certainly I would make it available to the committee through the written representations. I would have wished to take time to go through the process of this whole thing, but time constraints do not permit me. But a comprehensive determination had been made in that context. And I might say that the court, to very briefly say this, that the court was mindful of the separation of powers contained in the Constitution of Sri Lanka, and it was also mindful that the proceedings of this nature was a sui generis power of Parliament. And let me also bring to the notice of this committee that in his opinion, the Supreme Court, whilst noting this concept of separation of powers, set out the principle, the long established principle in public law, which I believe every one of us are aware of, which I might quote in the Latin maxim, nemo judex in causa sua, no man is a judge of his own cause. And that process was reflected in the opinion of the Supreme Court, which identified the entire concept of separation of powers and the proceedings that were taken before Parliament, because that was a sui generis power vested in Parliament in terms of our Constitution. So with all due respect to the observations made, I believe it would be appropriate that I make available these judgments for the perusal of the committee, so that they will appreciate the fact that this was a constitutionally mandated procedure, and clearly the constitutional stipulations were followed. The parties concerned were given opportunity to present its material before the committee, and even the proceedings of that committee were very comprehensively dealt with, and clearly the pronouncements of the Supreme Court will bear ample testimony to that fact. I'm mindful, Mr. Chairman and Mr. Ambassador, of the time constraints. I wonder whether I have a few more minutes.
As a delegation, you have to finish.
I might just only, yes. So in that context, I would make this material available, and also make it very clear that this was a clearly constitutionally followed procedure, and that all appointments have been made to the superior courts strictly in accordance with the constitutional procedures prevalent in Sri Lanka, and there has been no contravention of that process, including appointments of the Chief Justice. And that has also been a subject matter of a Supreme Court judgment, and that process also, with great respect I say, has followed the clear constitutional provisions prevalent in Sri Lanka. So with that, and bearing in mind the time constraints, I would conclude and provide further responses in writing, so that the committee may appreciate the views that we have expressed in this deliberation. Thank you.
Mr. Chairman, members of the committee, in responding to a few issues and also winding up, let me first say that just as much as I very readily apologized for one reference which was made of naming a country of a commissioner, we feel that in the questions read by some of the commissioners, that sensitive nuances must be also taken on board and the sensitivity shown. I particularly refer to the reference by one to parts of Sri Lanka as belonging to one community, very specifically in the form of, I quote, Tamil Elam, because this is the basis on which Tamil homeland, which is the basis on which the 30-year separatist conflict was fought. There was never a mandate given by anybody in any election for a separate homeland, but all citizens in Sri Lanka are free to choose their place of residence regardless of their ethnicity. And it should be noted that a large majority of Tamil and Muslim community lives in Sri Lanka. In fact, the percentage in Sri Lanka of the Muslims and Tamils put together is much more than the Sinhalese community, which is the majority community. And any lands acquired for state purposes in any part of the country is done under the Land Acquisition Act, and compensation or alternative lands are provided. The second reference which I take exception to is that of Mullivaikal Day, because I do not know whether the member who mentioned it remembers that Mullivaikal Day is celebrated to commemorate the LTT leader, Velupilla Prabhakaran, who met his death on that day. Now, whether it is the norm that terrorist leaders and the places they died are venerated and commemorated in this civilized society is a question I leave to you, learned ladies and gentlemen, to answer. But I must say that to us in Sri Lanka, while we do mourn all those who have died and allow the families to do so on that day, there is a sense of glorification of terrorism by allowing that to be done with respect to leaders of terrorist organizations and senior terrorist cadres in particular. Now, as far as the whole discussion has gone, in winding up, what I want to say two things. And one is that you would note that many of these questions which have been posed to us are questions which face many countries which are in the state of the same state, comparable states of development and comparable states of socio-economic progress. And I would think that from our responses to some of these areas in particular, that you would appreciate that we are leaps and bounds ahead of even countries in the developed world in terms of some of these indicators. And this, I think, is a factor which I hope the Commission to which we are, the committee to which we are coming to after a lapse of 11 years would appreciate. And the transition that has taken place from a country fighting terrorism for 30 years to now a country which is just out of it for 5 years and is trying to address the matters like normal countries start doing. But the transition, as many of those countries who have come out of it would know, is not so easy, and there are problems in trying to approach this. The other aspect I wanted to mention was that in judging Sri Lanka, as I said yesterday, in relation to the PTA, but in relation to several other issues, my colleague reminds me that I seem to have said that the Tamils and Muslims are over 50% only in Colombo, in the Colombo area. But they are widespread in many other parts of the country as well. The other point I was wanting to make was that in judging Sri Lanka, conscious of what we went through, that the challenge we take and continue to take as a country as emerging from a conflict should be taken in proportion with the challenge we faced. And I made the point yesterday and I repeat it today that Sri Lanka does not shy away from taking considered choices and is adept as differentiating in the best interests of its people. So when we take a deliberate choice and a calculated risk to allow IDPs to go without too much scrutiny, to allow ex-combatants to go after some rehabilitation, that is a considered risk. But that was a risk which we took because we felt comfortable to do so, that the society will not be unduly harmed and that this was calculated. But when on issues like PTA and on some of the precautions we take in the northern and eastern provinces in view of what is happening on the ground, in view of our consciousness of the capacity that still a large part of the LTT's arsenal probably remains buried with some people knowing where they are. You must take into account that we have to tread with caution. And I think that I go back to the point that there are many countries who have similarly acted, who have had to face the same problem. There was also the question I want to make that there seemed to be a sense of prejudgment of the Commission of Inquiry that is taking place on disappearances, which mandate has been broadened. And I want to say very clearly that with respect to commissions, contemporary history shows us that, ask yourselves how long the Bloody Sunday investigation took, how long the Royal Commission of Aboriginal People in Canada took, even the South African Truth Commission, the Commission on Truth and Reconciliation in Congo, the Commission in Colombia, National Commission for Reparations and Reconciliation. And let's not forget that the Chilcot inquiry, officially launched on 30th July 2009, the report is still to see the light of day. Now, in Sri Lanka's case, when the LLRC was sitting, everybody said, this is useless, this is hogwash, the report will never come. When the report came, it was said, when the report was given to the president, it was said, it will never be published. When it was published, it was said, Sri Lanka will never implement it. When a national plan of action was put in place, it was said that it was not practical. And now there was a question about the number of recommendations, how it has been watered down. But my colleague answered how the decisions had been made. I'm concluding, Mr. Chairman. So therefore, all I ask is that members of this committee, as I said yesterday, we are deeply respectful to the questions asked, and I want to assure you that Sri Lanka is doing all possible. And I have with us the colleagues leading the main ministries which are involved in this, and we take back home from this interaction the consciousness about these matters. We will try to respond to you as much as we can in the next 48 hours, but we take back the points made by you and the sensitivity you show to some of these issues, and we will, may not be immediately in this fora, but in others, be responding to those as time goes by. In concluding, I wish to thank you and other members of the Human Rights Committee for the fruitful discussion that we have had during the course of the past afternoon and this morning. I'm only sad that we did not have more time and to more extensively address some of the issues, considering the very significant context in which Sri Lanka has had to ensure the upholding of its human rights for its citizens. I also want to thank the Secretary and the staff of the committee, as well as the interpreters and conference services for help in spite of the fast reading or speaking, for keeping abreast with us. And on behalf of my delegation, I wish you, Mr. Chairman, and the committee all the very best for the rest of the session, and I wish you a good afternoon. Thank you.
Thank you very much, Ambassador Arias Sinha. And we share your sadness that we can't spend more time together to go even more deeply into some of these very important and indeed sensitive, often, issues. Let me just say right at the beginning that we're not judging Sri Lanka. It's been suggested that from time to time that we might be. We're not judging Sri Lanka. What we're trying to evaluate is the extent of Sri Lanka's compliance with specific provisions of the International Covenant on Civil and Political Rights, to which it is a party and without reservation. We also don't do comparisons. We're not in the business of saying, well, this country's better than that country, so we don't have to worry about it. Obviously, we're familiar somewhat with international practice, because international practice may help elucidate the interpretation of the covenant, but that's a different matter. A couple of times you have said, I've got a camera staring at me and it's really being a little bit disconcerting, sorry. From a distance would be fine. I look better from a distance. From time to time you've referred to the issue of disproportionality. And indeed, disproportionality is an issue that is built into international human rights law and built into the covenant, or rather proportionality is as a test for evaluating the legality of certain acts and omissions. But it is a legal test, not a political test. It's not just simply up to politicians to decide, well, we had to do this, therefore it's okay. To take the example of reversing the burden of proof for admissibility of confessions, every international treaty body recognizes that when a person is in the hands of the detaining and interrogating authorities, they are, by definition, unable, in fact, they're deprived of the means of providing proof of their allegations. The responsibility has to be, whatever the circumstances, on the state party to demonstrate that statements were made freely and fairly. I'm no expert on my own country's practice, though I'm pretty confident in saying that even throughout the recent troubles my own country has gone through, there was no suggestion that it was up to individuals to prove that they had been ill-treated in a voir dire. It was, if there were to be a voir dire, it would always be for the authorities to show that a statement was made freely and voluntarily. But I don't want to get into comparisons. The point is that even if I'm wrong, that would be the sort of issue that this committee, without my participation, of course, would call to the attention of the UK authorities. We recognise that Sri Lanka has come to the end of a bloody war, fought against a party that didn't hesitate to resort to terrorist methods in achieving their objectives. We do indeed recognise how important it has been for so many people displaced by the conflict now to be being resettled, and indeed the fact that admitted combatants have now also been able to be resettled. That's a good transitional process. That doesn't mean, however, that that's all there is to it. Either within the context of the conflict or not, over the years, there have been substantial, and over the decades, allegations, often vindicated by international authoritative bodies, of widespread disappearances, fewer in recent times that are reported to the Working Group on Disappearances, extrajudicial executions, and certainly torture, which was found to be a systematic practice very recently even by the Committee Against Torture, as pointed out by Mr. Newman. And zero tolerance or no zero tolerance, if it's happening, the means of enforcing that zero tolerance obviously need to be reviewed. The question of impunity has been raised by several colleagues. I won't take it any further at this stage, but just to indicate that it's likely to find its reflection also in the concluding observations. I didn't hear a response to the question as to whether there'd be any progress relating to the whether the state party would begin to recognize rape and therapeutic purposes as legitimate means, purposes for abortion. Certainly this committee doesn't begin to understand how a woman can apparently be called upon to have a child inflicted on her by virtue of an act of overpowering her. On the question of personal laws, I would point out just a legal point, because we may not be able to make it in too much detail during the in the concluding observations, that Article 27 is not a collective article, it's an individual rights article. In those states in which ethnic, religious, or linguistic minorities exist, persons belonging to such minorities shall not be denied the right, in community with other members of their group, to enjoy their own culture, to profess and practice their own religion, or to use their own language. Shall not be denied the right. That is not the same thing as shall be expected to submit to the majority understanding of what is appropriate behavior or isn't. There's Article 26, which requires equality of rights under the covenant and non-discrimination of rights under the covenant, and Article 27 complements it. It doesn't trump it. I understand that it's a Supreme Court interpretation of the covenant. If so, it's an erroneous interpretation of the covenant, as obviously was the Singarasa case, where, as already pointed out, the Supreme Court, not on the instance of the government, I'm aware, but of its own motion, decided that the committee's consideration of individual cases and emitting views was to be equated with an external jurisdiction. Obviously, it's going to remain a problem for this committee that the state party is not cooperating with cases submitted under the optional protocol, which ratification of which was duly deposited with the Secretary-General, and which is conclusive for the committee in terms of its own jurisdiction. And it would be so much more helpful if the state party, whatever it is, 7 years after the Singarasa case, could find some means of renewing its cooperation with the committee on individual cases. Obviously, what I've said, as already indicated by Mr. Sital Singh, also is connected with the issue of independence of judiciary and other independent bodies, and whether it's the impeachment of the former Chief Justice and the process by which it was conducted, whether or not the resultant Supreme Court considered it constitutional, or whether it's the 18th Amendment to the Constitution. There are likely to be questions in our concluding observations about that, given the interest expressed by members. What I've said is without prejudice to the what the eventual concluding observations will be, of course. Meanwhile, I just want to finally wind up, and I'm grateful to the interpreters for the extra time they've given us, by thanking the delegation very much for its diligent responses under the very difficult time conditions we've had to operate under. A delegation composed of responsible senior people from all the relevant departments of government. It's really contributed very much to our understanding of the situation in relation to respect for the rights protected under the covenant, and we'll look forward eventually to continuing the dialogue in terms of our follow-up procedure once the concluding observations have been adopted. Meanwhile, just to recall that there are the 48 hours from now for the receipt of written observations. So with renewed thanks to the delegation and wishing you all safe home, I suspend the session.